Welcome to Pass Law Exams. I am your guide to passing your law exams, one topic at a time. Today we are looking at offer and acceptance, one of the most fundamental concepts in contract law. Let's get into it.
You walk into a shop, you pick up a product, you take it to the till. Has a contract been formed? The answer depends on whether there was a valid offer and a valid acceptance. Get this wrong in your exam and you fail the question. Let's get it right. An offer is an expression of willingness to contract on certain terms, made with the intention that it becomes binding upon acceptance. But here is the trap every student falls into. Not every communication is an offer. The goods on that shop shelf? That is an invitation to treat, not an offer. The shop is inviting you to make the offer. The classic case is Pharmaceutical Society of Great Britain versus Boots, 1953. Advertisements are generally also invitations to treat. See Partridge versus Crittenden, 1968. The exception? A unilateral offer made to the world, like the famous Carlill versus Carbolic Smokeball Company, 1893. The company offered £100 to anyone who used their product and still caught influenza. That advertisement was an offer, and the court held the company to it. Now, acceptance. For a contract to be formed, the acceptance must be a mirror image of the offer. Every term, no additions, no conditions. If you try to add a new term when accepting, that is not acceptance. That is a counteroffer. And a counteroffer destroys the original offer completely. The authority is Hyde versus Wrench, 1840. The acceptance must also be communicated to the offerer. Silence alone cannot be acceptance. See Felthouse versus Bindley, 1862. And remember, acceptance can be by conduct as well as words. In Brogden versus Metropolitan Railway Company, 1877, the parties performed the contract without any formal written acceptance, and the court found a binding agreement. One final rule you must know: the Postal acceptance rule. Where it is reasonable to use the post, acceptance is complete the moment the letter is posted, not when it arrives. The authority is Adams versus Lindsell, 1818. But note, this rule is an exception. It does not apply to emails, faxes, or instantaneous communications. Those are governed by the general rule, acceptance effective only on receipt. So, to pass your contract law exam on offer and acceptance, identify the offer, distinguish it from an invitation to treat, ensure the acceptance mirrors the offer exactly, and check how and when acceptance was communicated. Subscribe to Pass Law Exams for more tutorials and visit passlawexams.com for full study support. Pass Law Exams, because passing is the only option.